session.
Please be seated. Okay, one case on the docket this morning, ID versus Templeman. Are both sides ready?
Yes, Your Honor.
The appellant may proceed.
May it please the Court. My name is Tracy McFarland, and I'm one of the attorneys representing the appellant ID, the defendant in the action below. And I would request 5 minutes for rebuttal. ID, who is a former foster child, has been injured by the state of Florida, not just once but twice now. The first time by a former state employee who was deliberately indifferent to her constitutional right as determined by a jury on her civil rights claim. And then by the Department of Financial Services when it sued her, seeking to avoid its statutory duty to pay that final judgment. And the issue to be decided by this Court is whether the Department of Financial Services is obligated to pay that final judgment on a claim entered on a civil rights claim that contains no finding that the defendant intentionally caused the harm as required.
You used an interesting term, though. You said deliberately indifferent. How does somebody do what this person did and not intend to cause harm?
Deliberate indifference, by the very nature of the term, does not require a finding of harm. As defined by the Supreme Court in Farmer v. Brennan in 1994, deliberate indifference, as they defined it, entails something more than mere negligence, and the cases are also clear that it's satisfied by something less than the acts or omissions for the very purpose of causing harm or with knowledge that harm will result. Deliberate indifference in and of itself does not automatically imply an intent to cause harm. And
how do you do what this person did and not intend to cause harm?
That was not a finding that was raised or determined by the jury. And there are issues that could have been raised and defenses that could have been provided to address that had that issue been raised at the trial below.
Let me ask you about the trial below. Mr. Templeman, he was in prison at the time of the trial below, or the 1983 action, wasn't he?
Yes, Your Honor.
What level of participation did he have in the trial?
He proceeded pro se.
Was he actually there?
He was present for the trial and participated throughout the entire proceedings. Yes, Your Honor.
And he was sued in his individual capacity?
He was sued in his individual capacity as a former state employee.
The state of Florida are an agency of the state of Florida, a party to those proceedings?
No, they are not, Your Honor. 1983 claims are required to be filed against the state actor in their individual capacity. Pursuant to the risk management certificate of coverage for civil rights claims, there is an absolute duty to defend those employees on any civil rights claim that is filed against them. DFS was notified of the action and for whatever reason chose not to participate, chose not to raise any of these issues at the...
Who would have participated in the trial would have had an interest in having a jury finding of intent to harm? Would that have been to anybody's benefit that participated in the trial?
Obviously, it certainly would have been to the department's benefit to seek to participate for that purpose, to request that the jury at least consider that issue and make a finding as to whether or not there was or was not intent.
But if they participated, they would be acting as Mr. Templeman's representative, so they would not want to have a finding of intentional harm, wouldn't they?
The attorney representing Mr. Templeman, you are correct, would not want to raise that issue.
Well, you misunderstood. Maybe I wasn't clear. If the department was defending Mr. Templeman in the 1983 action, they would be doing their darndest not to get a finding of intentional harm, correct?
You are correct, yes.
So in essence, the only interest the department would have had to assert, something to get them out of coverage would be against the interest of the party who they were allegedly there defending, right?
You have correctly assessed the situation, yes. And I would offer that they could have sought to intervene as the department itself for the limited purpose of seeking a jury interrogatory specifically on that issue. Had they so in fact done, any defenses or arguments with respect to the intent issue could have been raised by ID at the time of the trial evidence presented in response to those arguments, and the jury would have had the opportunity to rule on those issues. That wasn't done. There was no action by the department whatsoever to in any way participate in this trial. And now they're seeking to collaterally attack that judgment and impute findings that were never made by the jury and are not required to be made by the jury. As this court noted in Clemens, on a claim involving conspiracy to violate civil rights and malicious prosecution, that those claims do not necessarily imply that the officers intended to harm the plaintiff, because conspiracy does not require a finding of specific intent.
Counsel, Section 768.28 does provide for certain limitations in terms of suing the state of Florida or an agency of the state of Florida. Is that not correct?
You are correct, and those are for general common law negligence or tort claims.
Yes, but the section also says, this 768.29A, the state or its subdivision shall not be liable in tort for the acts or omissions of an officer, employee, or agent committed while acting outside the course and scope of his or her employment, or committed in bad faith, or with malicious purpose, or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. By the very nature of the alleged civil rights violation that's committed here, that is sexual battery, wouldn't that be an act exhibiting willful and wanton disregard of human rights, safety, or property?
I respectfully disagree, Your Honor.
Why not?
Simply because 768.28 does not apply in any way to federal Section 1983 civil rights claims. And Section 768.28 was specifically amended in 1979 to eliminate any language that
the state of Florida has 11th Amendment immunity from a Section 68, from a 42 U.S.C. Section 1983 civil rights claim.
There is no sovereign immunity associated with those claims. They are brought against the individuals.
There's 11th Amendment immunity associated with those claims, isn't it?
I beg your pardon?
Isn't that 11th Amendment immunity associated with those claims against an agency of the state of Florida
Against
or the state of Florida?
Yes, you're correct. However, that was the purpose of the enactment of 28438, which specifically provides that the Department of Financial Services will pay judgments arising under 42 U.S.C. Section 1983 unless the officer, employee, or agent has been determined in the final judgment to have caused that harm intentionally. There is no language within our final judgment that the harm was caused intentionally.
By saying that, you're asking us to hold that the certificate of insurance that's issued and adopted by rule is in fact illegal or unauthorized.
That subsection E under the, I believe it's E, under the exclusions that provides the language just read by Judge Lewis from 768.28 is extraneous and not authorized by statute. As Judge Benton noted in his concurring opinion in Clemens versus Risk Management, that language is specifically extraneous and relates solely to...
But that is a concurring opinion, correct, counsel?
Yes, it is, Your Honor.
So it's not controlling.
Agreed. But I think it is enlightening and provides guidance for the position that we're taking. The limiting language is in contravention of the statutes. 28438 makes it very clear the only limit to be applied when deciding whether or not to pay a judgment is whether that judgment contains a finding of specific intent. This judgment does not...
I guess what troubles me is, essentially what you're asking us to do is hold the state financially responsible for the criminal acts of one of its employees. And to me, that's just, that can't be what the legislature meant, can it?
It is. The cause of action on which this claim was based was deliberate indifference to a foster child's right to...
The cause of action on which this claim was based was that a employee of the state of Florida sexually assaulted a foster child. That's what you alleged in your complaint. You didn't say deliberate indifference. Maybe that's the legal buzzwords, but you alleged the specific act of sexual assault.
And we also alleged that the claim was premised on his deliberate indifference to her right to reasonable safety while in state custody. And that is all that the jury determined, that the defendant was deliberately indifferent to her right to reasonable safety.
I get back to, sexual assault like this, how do you not intend to cause harm? I mean, that's where I'm getting hung up.
And there are defenses that could have been raised, such as diminished capacity, insanity, a lack of understanding or knowledge. Those defenses have been acknowledged to exist in both Landis versus Allstate and Allstate versus McGraney.
So you're saying, I mean, the bottom line, though, to raise those defenses, you're saying the state has to become, or the insurance fund has to become a party to all of these actions, because that's the only way those defenses are going to get raised.
And that's exactly what I'm saying. And that's the only fair way to present it. Otherwise, the jury has long since adjudicated the issues. There is no full and fair opportunity for ID at this point to address any of that and have those issues determined.
What happened to the tort action against the Department of Children and Families? I understand it was dismissed.
The state tort action was dismissed, yes.
Isn't that traditionally the way these claims are brought forward? You bring a tort action for negligent supervision, failure to hire, those sorts of things, and then you go through the sovereign immunity process, tort waiver, claim bill. Isn't that how these things typically run their course?
Not in my practice, no, Your Honor. They are typically brought as Section 1983 claims against the individual state employees. And this is the only time from all of the claims that we have brought that the state, first and foremost, abdicated its duty to defend, and then it has now sued ID to avoid its statutory duty.
Let me ask one other question. I know it may not be in our record. Did Mr. Templeman plea, or was he found guilty by a jury?
Mr. Templeman is not in jail for any acts associated with ID. He was in jail for some other completely unrelated event to the events at issue in this case. He was not prosecuted for this. He is not in jail for anything to do with respect to this child.
Counsel, would you agree that sexual battery by itself, in and of itself, does involve an intent?
I believe it can. I believe there are defenses associated with that. Again, insanity, diminished capacity, for which the defendant would lack the necessary mens rea, the necessary understanding or capacity to know that what he was doing, or, that the acts were not necessarily volitional. And there's no way to know whether or not that's what had occurred in this case, because, again, those issues weren't raised, they weren't addressed, they weren't litigated, they weren't presented to the jury, and there was no finding on that issue in any way, shape, or form. It just wasn't presented. And a plaintiff in a civil rights case, simply because the department refuses to participate, cannot be forced and should not be forced to conjure defenses that could be raised at a later point in time and then defend against those defenses, present evidence, against essentially a phantom participant on the off chance that they will be allowed to collaterally attack the judgment later because they stood idly by and did nothing.
Okay, you're down to about 2.5 minutes. What I'll do is give you about 4 minutes for rebuttal. Would you add about a minute and a half? Or, tell you what, add 2 minutes to the other side and add 2 minutes to your rebuttal.
Thank you, Your Honor.
May it please the court, Len Hackett, Verners and Bowen, on behalf of the Department of Financial Services. The first issue we'd like to bring up in front of this court is that we don't believe that ID has standing to challenge the issues which are before this court. As this court knows, there are two duties that any carrier has, which is a duty to defend and a duty to indemnify.
What would give them standing? Would they have to have an assignment from Mr. Templeman?
Yes, Your Honor, I would say they would have to have an assignment. They are not a party to the insurance contract. All of the cases which I've seen in which a similar circumstance has been presented to the court is they have had an assignment of rights from the insured and are going forward.
I understand your argument. Go ahead. I understand your argument on the duty to defend. I'm really having a difficult time on the duty to indemnify. How are they supposed to get out at this fund? Aren't they a beneficiary or third-party beneficiary of the insurance contract?
Your Honor, I would say the only way they can get after the fund after getting a judgment would be to get an assignment from Mr. Templeman and to move forward against the fund. I mean, they have a judgment against Mr. Templeman. Their relief is to satisfy that judgment against him.
Mr. Templeman's a deadbeat and doesn't care about having a judgment against him. They have no way of getting to the fund.
Your Honor, I don't disagree. That may be very unfortunate for the plaintiff in collecting the judgment, but I don't think that fact provides them a legal standing in which to sue the fund directly without an assignment from Mr. Templeman.
But as a state employee, wasn't Mr. Templeman insured under the fund?
Your Honor, he wasn't insured, but he was not provided coverage as a result of an exclusion contained in the appropriate certificate of coverage.
Which aspect of the exclusion did the fund rely upon? The intentional component or the, I'll use the words that were in the judgment, the deliberate indifferent, the one that was questioned by Judge Benton in his concurring opinion?
Your Honor, I would say the provision that was questioned by Judge Benton was indeed the exclusion that the Department of Financial Services relied on. The exclusion states in part, one exclusion provides that coverage does not apply to actions of insureds committed in bad faith or with malicious purpose or in a manner exhibiting wanton disregard for human rights and safety.
Does that equate with the causing the act intentionally?
Your Honor, I don't see how you can say that the act was not caused intentionally. I would say...
Whoa. The language you just used, bad faith, malicious purpose, willful disregard, does that equate with the word intentionally or doing an act intentionally?
Your Honor, I would say it does, and I would say doing an act intentionally goes above and beyond what that exclusion provides.
Oh, I agree, doing an act deliberately. My question is, if there is a difference between those, aren't you at that point conceding that you've gone beyond the statutory authority in drafting the certificate of coverage?
Your Honor, I don't believe so. I understand Judge Benton's concurring opinion, and he's looking at some specific language in 284.38, which provides the limits provided in 768.28 shall not apply to civil rights actions under 42 U.S.C. 1983. Your Honor, where I disagree with Judge Benton is the term limits.
Judge Benton for a second.
Okay.
I want to concentrate on a problem I'm having.
Okay.
The statute says one thing. You just told me, if I understood you correctly, that the certificate of coverage says something different and there is a different meaning. If, in fact, there is a different meaning between the statute and the certificate of coverage, why have you not contravened the statute, and do you have the authority to do that?
Your Honor, my response to that question is I don't think we're in contravention of the statute. I don't think the statute precludes the Department of Financial Services from adding this exclusion into its certificate of service.
So what you're basically saying then to me is that essentially these two are the same, or is that not your argument?
Your Honor, it's not my argument, Your Honor. And maybe I'm not understanding the court, and I apologize.
If that exclusion is more than what's in the statute, where do you get the authority to adopt that exclusion? And I'm going to basic administrative law here now.
I understand what you're saying, Your Honor. Your Honor, because we may be couching or stating that, and I think there's no doubt that Mr. Templeman's actions were intentional, I don't think the fact that they were intentional, and that's the term we're using, necessarily leads to the conclusion that the state cannot rely on an exclusion which provides that the actions of assured committed in bad faith or malicious purpose or in a manner exhibiting wanton disregard
I guess
is
that's
different.
the problem. By adopting 284.38 and said these acts are excluded, or limitations or exclusions, hasn't the legislature basically occupied the field and said these are the exclusions you're allowed? Exclusio unius alterius.
And, Your Honor, where I'm trying to get this court back to is that the limits referred to by the legislature in 284.38, in the state's opinion, refer only to the monetary limits. You know, if you look at the case law interpreting 284.38 in that section, the limits provided in 768.28, when you say the limits in 768.28, what naturally comes to mind is the monetary limits. Underneath 768.28, the limited waiver of sovereign immunity applies to $100,000 and to $200,000. In the case law introduction, which we cited, the Gamble and the Shinhole case.
Here, let me ask you this question, because I think where Judge Wolf is struggling, and I may be starting to struggle a little bit, is 768.28 is very clear, applies to tort claims, and it essentially says you cannot sue a state employee. You have to sue the government unless the state employee acts in bad faith, willful, wanton disregard, et cetera, et cetera, et cetera. They didn't sue them in that direction. They went 1983. And the 284 statute, while it would seem to capture the whole, if it said the state doesn't have to pay where there is willful or wanton disregard, et cetera, et cetera, et cetera, to tie it right back into 768.28, the statute simply says intentional act. And so I guess where I'm struggling a bit is, unless we were to construe intentional act to essentially mean what the department has construed it as in the exclusion, there appears to be a gap of cases that you can't sue the state under, and you can sue in tort, but you can't. So I guess, help us understand how these two statutes work together.
Okay, I will, Your Honor. And if I could read in the statute, just so we have a clear understanding. The limits provided in 768.28 shall not apply to civil rights actions arising under Section 1983 or similar federal statutes. Our initial position is the limits referred to.
I agree with you.
Okay.
That's the monetary limits, period,
and then
end
it
of
says,
story.
Your Honor, payment of a pending or future claim or judgment arising under any such statutes. Your Honor, I want to emphasize this word, may be made upon this act becoming law. It does not say shall be made upon this act becoming a law. And then the statute goes on and adds the additional provision which the court is referring to.
So you have a total discretion to pay or not to pay as you see fit. I mean, that's what I just heard you say. By the word may being in there.
Unless this court tells us otherwise, Your Honor, I would say that may be the case. Your Honor,
you issue insurance and you decide whether you're going to get the payoff.
Your Honor.
I'm on the JQC.
Okay.
Judicial Qualifications Commission. We have our insurance with the state. I'm a little nervous to hear you say you have total discretion to pay if I get sued, Your Honor.
Your Honor, to some extent, with all due respect to the court, a carrier, whether it be the state or carrier, always has the discretion to pay or not pay. Now, whether or not that discretion was exercised wisely in accordance with the law is another issue, and why we have the court system.
But, you take the word may out of context. It says, may be made upon this act becoming law unless the officer, employer, or agency has been determined in the final judgment to have caused the harm intentionally. Take that whole phrase together and tell me what that means.
Payment of a pending future claim may be made upon this act becoming law unless the officer, employee, or agent has been determined to the final judgment to have caused the harm intentionally. So how I see that, Your Honor, you may make the payment unless the final judgment says the harm was caused intentionally. Then you don't have to make the payment. And the harm caused intentionally, in this case, Your Honor, we think it can be inferred as a matter of law.
Okay, I understand that argument. I mean, that's probably your strongest argument here.
Okay.
Somebody sexually assaults somebody. But, okay, then respond to their argument that there could be an argument of diminished capacity. There could be insanity. I guess arguably there could be extreme drunkenness. Respond to that argument.
Yeah, Your Honor, they're citing that argument, and I believe it was DuPont v. Gallagher, for the position that we cannot go back and argue facts and or assert defenses which we could have asserted at the trial court. And, Your Honor, my argument, I don't disagree with that case law. And if I was before this court arguing diminished capacity, if I was before this court, this is a 1983 action, arguing qualified immunity, or if I was before this court arguing that the statute of limitations ran and the claim should have been filed, that is, if I was before this court arguing defenses, which I could have argued at the state court to void the judgment against Mr. Templeman, I would say that case law is applicable. Your Honor, that's not what I'm doing. I'm arguing before this court that we do not have a duty to indemnify underneath the statute. The duty to indemnify, Your Honor, is not a defense which I would have asserted at the trial court. It would have been inapplicable. It couldn't have been. So when they start...
Counsel, you have a duty to defend even under the statute, not indemnify, to defend under the statute.
Your Honor, and that's the first issue. The first issue that the Department of Financial Services had to address was, do they have a duty to defend? And, Your Honor, they made the decision based on the allegations in the pleading that no duty to defend existed. Mr. Templeman did not challenge that decision.
Therefore, if there is no duty to defend, then there's no duty to indemnify.
Your Honor, the duty to defend is broader than the duty to indemnify. In order to indemnify, you have to have a duty to defend. The duty to defend is not rightfully before this court. The decision of the Department of Financial Services not to provide the defense cannot be reviewed because Mr. Templeman is not arguing that fact. Plaintiffs cannot argue that fact, and Mr. Templeman has not assigned the rights over to the appellants. So our position, and that's one of our arguments in reference to standing, is that, the duty to defend...
Was there any way the plaintiff could have gotten it, could they have joined you as a party in this action and asked for a specific jury finding on whether this act was deliberate?
And Your Honor, it's an interesting question because the way the statute was written, and as this court alluded to during the appellant's argument, is there's no way the state could have protected their interest. With the exception of perhaps, counsel suggested, intervening. And if that's the case, I would profit to the court that intervening is not mandatory. It would be at the discretion of the judge. And then taking that a step further, the state would have to intervene in each and every case in order to get this interrogatory in front of the jury. Both counsel for ID and counsel for Mr. Templeman, if it was assigned, in my opinion, would be committing legal malpractice.
But counsel, how do you distinguish this case from the case cited by the appellant, Clemens versus State Risk Management Trust Fund?
Your Honor, I think this court...
In that case, this court found that since the judgment did not include the words intentional in it, there was no basis for finding that these officers committed an intentional tort. Therefore, the state was responsible to indemnify.
I agree with this court. But what this court did not do in the Clemens case is what the appellant is asking this court to do, is just look at the statutory language. There was no final judgment. What the court in the Clemens case did, Your Honor, it was a 1983 action. That 1983 action was based on malicious prosecution, was based on conspiracy, it was based on punitive damages. The first DCA went into each and every claim and looked at malicious prosecution. They looked at conspiracy, and they looked at punitive damages, and they found that you do not need a specific intent to be held liable for malicious prosecution, for punitive damages, for conspiracy. Our position is you need a specific intent to sexually molest and or sexually assault a child. So, Your Honor, in answer to your question is the underlying tort that forms the basis of the 1983 action for plaintiff's case distinguishes the case from the Clemens case.
Yes, must the final judgment include the word intentional in order for you not to indemnify?
And Your Honor, our argument is that the intent can be inferred by the underlying action. And
even though the final judgment does not include the word intentional in it?
Absolutely. Because, Your Honor, then I go back to my argument, Your Honor. How would the jury have been posed that interrogatory?
Well, that's kind of how I'm concerned here, whether the final judgment implies to me in the underlying tort action. I'm wondering how you ever get a finding in a final judgment,
Your Honor,
that there is an intentional act, because nobody's going to argue that unless the department is a party.
And they're not a party unless they're permitted to intervene, Your Honor. And Your Honor, that's the catch-22. There is no one there to protect the state's interest. Even if the state assigned a counsel and said, Mr. Templeman, we're going to defend you, that attorney has an obligation to his client, Mr. Templeman. He is not going to submit an interrogatory, which if the jury agrees with, which more likely than not they certainly would have.
It almost would put you in a situation where you're saying you don't have a duty to defend, yet you would be intervening to protect your argument on the duty to indemnify. I mean, that in essence would be what you'd have to do.
And, Your Honor, just to go a step further, whether or not we could be intervened would be left to the discretion of the trial court. It's not mandatory. It's permissible. So the state, under many circumstances, would not even be permitted to intervene.
Did the plaintiff have joined you as a party here? You shake your head no. That's a no in the appellate court, but I'll ask you that question, too.
Yeah,
I don't think so. The
Your Honor,
defendant probably could have,
Yeah.
might have tried to at least.
But, Your Honor, as you alluded to, though, the state entity in this case was the Department of Children and Families, and they had filed the state court actions 2 years before the 1983 action. They ended up dismissing the state court action. It was based on negligent supervision and allegations that the DCF failed to harm them. Your Honor, they could not go forward successfully with that claim. They dismissed it. And, Your Honor, to some extent, I tip my cap. It was good lawyering. They filed the 1983 act.
Sue the state or an agency of the state of Florida under 1983, Section 1983, for damages. Is that correct?
That's correct. It would be underneath 768.28, Your Honor, which is what they did. That case was ultimately dismissed.
In state court?
In state court. And then they turned around and had this 1983 action against Mr. Templeman, Your Honor, presumably knowing that the state was not going to provide a defense. They went forward against a pro se plaintiff, submitted themselves a final judgment, which clearly they were familiar with the statute, did not include the intent to cause harm. Why would it? And now they're coming forward and asking the state to indemnify Mr. Templeman.
Do you agree with counsel that Mr. Templeman was not prosecuted for this particular child? Is that correct?
Your Honor, it's my understanding that is correct. Mr. Templeman, just to give this court some background, was prosecuted for sexually molesting a neighborhood boy. Both incidences occurred at around the same time. The prosecutor, for whatever reason, chose to proceed only with the sexual assault and molestation of the neighborhood boy and not the appellant.
Thank you.
Okay, thank you.
Thank you, gentlemen.
To answer your specific question, could we have joined the Department of Financial Services in the federal civil rights lawsuit? The answer is no. Both the 11th Amendment immunity would protect them, and the 1983 statute specifically says no person acting under the color of state authority. So we would have no basis upon which to seek to bring them in.
Counsel, let me try this with you. I didn't do a good job with counsel there. What troubles me is there seems to be a disconnect between 768.28 and this statute. Under 768.28, the state is not liable in tort, and I understand it's tort in 1983, so there's a difference. But the state isn't liable in tort for the bad faith, intentional, willful, wanton acts of its employees. And if we accept your argument that the statute 284.38 is limited to intentional, I mean, wouldn't in effect the state then become liable for, in 1983, albeit rather than tort? But it's still the state, it's still the same pot of money. Wouldn't they then become liable for employees' acts that are in bad faith, willful, wanton, and whatever you have in your verdict?
Yes, because there are two different statutory issues here. One is a state negligence statute, 768.28, which was very specifically amended in 1979 to eliminate any of the references to the civil rights statutes.
But, counsel, based on the 11th Amendment immunity, the state or its agency cannot be sued in federal court for a civil rights violation. Is that correct?
Absolutely correct.
There's an absolute bar to suing the state or its agencies under Section 1983.
Absolutely. However, under Chapter 284, specific provisions were added, statutory provisions were added by the legislature to provide risk management insurance coverage specifically for federal civil rights actions brought pursuant to 42 U.S.C. Section 1983.
So your argument is either that acts as a waiver of sovereign immunity specifically as to civil rights actions. I mean, that's what it's entitled, so it's a separate waiver for those particular actions.
Absolutely. And
But hasn't the state of Florida provided in section 7, state point 28, that the state has not waived its 11th Amendment immunity to sue?
as to claims brought against the state for civil rights claims, those claims are brought against individual employees, and through Chapter 284, the Division of Risk Management has specifically determined, the legislature specifically determined that the risk management would provide state-funded coverage for insurance to
Is that
provide.
for the benefit of the employee, or is that for the benefit of plaintiffs? I'm thinking this out now.
It is
I
for
mean,
the,
if it's an insurance policy, is that the state saying, we understand that there's a gap here where our employees can be liable under civil rights acts. So we're going to, understanding that, we're going to provide coverage for our employees.
It is for the direct benefit of the employee to provide both the absolute duty to defend under those civil rights, in those civil rights claims, the state employee, and then thereafter to further protect the employee by paying those judgments so that the plaintiff is not seeking to obtain the payment of that judgment from the employee directly. So indirectly, the plaintiff does benefit from that by the payment of that judgment. But it is specifically for the protection of every single state employee that they are provided risk management coverage against civil rights claims.
In the underlying lawsuit here, was there any allegation that there was diminished capacity or intoxication on the part of Mr. Templeman?
Those issues were never even raised in any way, shape, or form. They were never addressed. There was absolutely no reason on our part or ID's part to do so because the issue of his intent was never raised by anyone.
Yeah, I'm a little concerned the way the statute's worded, that you're putting this issue at issue in every civil rights claim. That doesn't make sense to me.
And I believe the statute is very clear that unless the final judgment contains a finding of intent to harm, risk management must pay that judgment.
But I guess the question is, will it ever? I mean, when will a 1983 action ever include a finding of intent to harm? Because if I understand your argument and what you presented to the jury, you didn't have to present them that jury question because you didn't have to get to that hurdle. Is that right?
Correct. That's absolutely correct.
So the statute, I mean, his language here is...
And I would assert that that is for the legislature to further address.
Totally useless or totally extraneous.
And again, I would assert that that is for the legislature to address. There is a very specific, clear statute here that unambiguously says pay the judgment unless there is such a finding. If there is a gap, it's for the legislature to resolve, respectfully, not for this court.
Thank you.
Thank you very much, Your Honor.